morning all. My name is Lisa Stratton, and I appreciate the opportunity to speak before you today on behalf of this bill. To give you a little quick background on myself, I'm a graduate of the University of Minnesota Law School and a former member of its faculty, and the co-founder of a nonprofit that is dedicated to eliminating gender barriers. I also have consistently litigated cases of gender discrimination since 1997, and my job here today is to provide you with a legal perspective on why we need an equal rights amendment to the Minnesota Constitution. As I think everyone is aware, the only explicit right to gender equality in either the state or the federal Constitution is women's hard-fought right to vote that was included in the U.S. Constitution by way of the 19th Amendment. This creates a situation where a then sitting justice of the United States Supreme Court could say, as recently as 2011 and still true today, according to this viewpoint, certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. At present, this statement could also be made about the Minnesota Constitution, which brings us here today. What difference might a state equal rights amendment make? Enshrining the basic principle of gender equality in the Minnesota Constitution would make it clear that the citizens of this state expect its courts to apply a very high level of scrutiny to laws that create or reinforce gender disparities. It would make it clear that such laws have to be justified by a compelling state interest and must be found to be necessary to achieve it. This standard would simply place gender equality on the same footing as racial and religious equality. At present, under the federal standard, which is called intermediate scrutiny and is sort of in the eye of the beholder, the government's interest to justify a sex-based disparity only has to be important, and the law under review has to be substantially related to that interest. Obviously, a much wider scope of gender disparities caused by law could be tolerated under this so-called intermediate scrutiny that the United States Supreme Court uses to measure gender equality under our laws federally. The ERA here in Minnesota, number 2, would create a backdrop to the sort of hodgepodge of anti-discrimination laws we currently have in our state. And I could talk more about what we do and don't have, but that's the bottom line. And it's important to remember that an ERA based on gender equality would protect men as well as women from laws and policies grounded in unfounded gender stereotypes. As a law professor noted in the film Equal Means Equal, which I greatly hope that some of you, if not all, have seen, he said the ERA, and I think this is important, it's not just a women's rights amendment, it's an equal rights amendment. Men would also benefit from the principle of gender equality, especially when it comes to their families and their relationships with their children. Another reason the ERA would give this legislature clear guidance for future legislation and a mandate from the citizenry. It would be another tool for advocates to use to attack the remaining manifestations of gender inequality in our state, which are many and are profound, as I believe other testifiers will share with you. Finally, a Minnesota ERA would continue the great tradition, which actually brought me to Minnesota as my adopted state, of Minnesota serving as an example of global leadership on women's human rights and gender equality. It is often used as an excuse by federal legislators that we cannot have a federal ERA because the federal government cannot mandate to the states that it take action with respect to the state laws. And international conventions, that is the norm. The government must guarantee all levels of government will comply with gender equality. So let's remove that as an impediment to the United States not remaining one of the only 7 countries in the entire world that has not ratified the International Bill of Women's Rights. No one can predict exactly what effect, at this moment, the addition of an ERA to our state constitution would have. But I can say with confidence it would not be immediate, it would be incremental, and it would happen as a result of legal challenges And those challenges would invoke a very deliberate process of evaluation governed by rules of evidence and procedure. It is a broad statement of principle, a goal
We are
by
at
which...
5 minutes, just so you're aware.
Ooh, so sorry. Okay. I then will wrap. I don't want to take away from other testifiers. We have been a leader in Minnesota on women's equality in many different ways. I urge this committee to continue that track record and pass House File 13. Thank you.